When it comes to the social justice in India, that is again moving towards a very transformative phase. The Karnataka cabinet that have cleared the Rohith Vemula bill 2026, and just a few days before we have seen that the UGC had released equity regulations which had now been stayed by the Supreme Court. So when it comes to the caste, campus and the constitutional promises, they are going through a transformative phase when it comes to the India. So we'll be talking about this particular topic in today's session. Along with me, my name is Bhanwarsingh. I am ex-NDA 115th course and qualified civil services in 2012, and I welcome you all on the platform of StudyIQ. Now, when it comes to both the things that we will be discussing, so there had been a state action where the Karnataka cabinet has cleared the bill. Karnataka cabinet approved the Karnataka, the Rohith Vemula Prevention of Discrimination Bill 2026. And this bill, it aims to eradicate the caste biasness via strict civil penal remedies, including there would be 10 lakh rupees of the fine and even 1 year of the jail term. And also when it comes to UGC, so UGC had notified the promotion of equity in higher educational institution regulations 2026 that had replaced the toothless 2012 guidelines. But like I said, that it had been currently stayed by the Supreme Court, citing ambiguous clauses, highlighting that there are structural complexities in the enforcement of the notification that had been notified by the UGC or University Grants Commission. Now, why this is important? Because when it comes to the operation of the vulnerable classes, when it comes to the higher education institutions, so in 2016, there had been a case, the case of Rohith Vemula. This was in the University of Hyderabad, and he died by suicide because of the operation that he met. And this has exposed the institutional apathy, and there were lots of protests, lots of demonstrations that were organized later on. Also in 2019, there was another case in Maharashtra, Dr. Payal Tadvi case, which had triggered the various PIL. A PIL was filed combinedly by the mother of Rohith Vemula and Dr. Payal Tadvi in the Supreme Court by both the grieving mothers. The Supreme Court have directed in 2025-26 the UGC to notify the new regulations, and ultimately we have seen that Karnataka had drafted a state law for the same thing. Now, when it comes to the Rajya Sabha, according to the Rajya Sabha data, there had been total 98 suicides of the Dalit, Bahujan and Adivasi students. They have lost their lives in the elite higher educational institutions, whether it is IITs, NITs or IIMs between 2019 to 2021. All right, so just in 3 years, there had been total 98 of the suicides that happened. Now, when it comes to both the acts or the regulations that we are discussing, how there had been changes that had been proposed. Now, when it comes to UGC 2026 regulations, so this would have been applicable to all the recognized higher education institutions nationally. At the same time, there would have been equal opportunity centers that would have been set up, and equity squads as well. There would have been equal or inclusive representation when it comes to the quotas, and withholding or rejecting central grants would have been how the institutions they would have been penalized, or how the UGC would have taken the punitive action. All right. At the same time, these guidelines or these regulations, it was for, or there were other backward classes that were also included along with scheduled caste, scheduled tribes, and ultimately that was the reason why there was a protest that were organized all throughout India, and the Supreme Court then directed UGC to take it back and ultimately formulate the another guidelines that will be again in very near future. They will be formulated by UGC. Now, when it comes to Karnataka cabinet have passed the Rohith Vemula bill. Over here, it will be applicable to all the public and private higher education institutions which are within Karnataka. Over there, there will be equity committees that will be established, and it is mandatory that in these equity committees, mandatorily 80% of the members will be from scheduled caste and scheduled tribe. And ultimately, when it comes to the punitive action, there would be up to 1 year jail and 10 lakh of the institutional fine, along with rupees 1 lakh of the student compensation that had been included in this bill. Alright, now when it comes to the Karnataka bill, this is the complete architecture that what will happen, that it mandates that there will be equity committee where 80% of the appointed members, they will be from scheduled caste or scheduled tribe communities, and it will fundamentally neutralize the illusion of impartiality. When it comes to the committee, it must be headed, the head of the committee, equity committee, the head or the chairman of this committee would be a scheduled caste or the scheduled tribes member. He will be assistant professor rank or above, and it will include at least 2 of the scheduled caste or the scheduled tribe student members as well. Alright. At the same time, it explicitly recognizes indirect discrimination as well. We have seen in the institutions what happens is not direct but indirect discrimination, where neutral rules that disproportionately harms the scheduled caste or the scheduled tribes, that is also being recognized by the law or the bill, and also the institutional discrimination, that is where we have the systemic biasness in the councils and the procedures. The institutions must act upon the equity committee's recommendations within a strict 30-day timeline that is also had been mandated by this particular bill that had been cleared by the Karnataka's cabinet. Now over here there will be escalations of the penalty. The first step will be restorative and administrative penalty, where there will be reconciliations. It will include written apologies, good behavior bonds and community service, and also it may lead to exclusion from examination or demotions as well. At the same time, the second step would be the civil and financial penalties, where the fines of 10,000 rupees can be imposed for the guilty individuals, and the courts, they can mandate the monetary compensation of up to 1 lakh rupees that may be paid or that will be paid directly to the affected person or the student. And then there will be severe institutional and penal actions as well. There may be imprisonment for up to 1 year for the first offense. There will be escalating to 3 years. Alright, that will, if there is the repeated offense, there will be, or the jail term, it may escalate to 3 years, and 1 lakh fine for the repeat offenses that had been provided in this bill. Along with this, institutions violating the law, they will face massive fines between 1 lakh to 10 lakh rupees. The state government possesses the power to suspend or revoke the financial assistance and the grants to the offending institutions that has also been included in the bill. Now, when it comes to the safeguarding of the rights of the oppressed classes, so there had been a complete framework that had been laid by the Constitution as well as through the various statutes that we have in India. Article 14, that is there in the fundamental rights, that promises equality before law and equal protection of law. That is, we have the right to equality. At the same time, Article 15 and Article 16, in both the articles, the clause 4, it is where we have the special provision for advancement of the socially as well as educationally backward classes. We have a directive principle that had been included in part 4 of the Constitution, and that is Article 46, that mandates the state to promote the educational economic interest of the scheduled caste, scheduled tribes, and also to protect them from the social injustice. Then we have Article 338. We have Article 338 and even Article 338A. Alright, both the articles, 338, that leads to, or that is for the formation of the National Commission for the scheduled caste, and we have Article 338A, that is for the formation of the National Commission for the scheduled tribes. Again, these are again the protective framework that we have in the Constitution. Along with this, we have the statutory frameworks as well, where we have the Scheduled Caste, Scheduled Tribe Prevention of Atrocities Act that was passed in 1989. We have Protection of Civil Rights Act 1955, and even we have the Right to Education that was passed in 2009, which have the anti-discriminatory ethos which had been planned or planted in the Right to Education Act. So these are the some of the statutory and the constitutional provisions which relates to the oppressed classes in India. At the same time, there is the dilemma as well, because when it comes to these oppressed classes or scheduled caste and the scheduled tribes, so they had been excluded in the elite spaces as well. Now, when it comes to the IIT Bombay, So from 2015 to 2019, despite the applications, the PhD admissions have yielded only 1.6% of the scheduled tribes, 7.5% of the scheduled caste, and 19.2% of the OBC candidates. So that means the majority of the PhD applications or the admissions, they were for the general classes. At the same time, when it comes to the evaluation biasness, so the RTI data that reveals that when it comes to the scheduled caste, scheduled tribes or the OBC candidates, they score high on the written entrances. But when it comes to the interviews, the subjective interviews, they face systematic low scores over there. So there is a subjective evaluation biasness that is also this RTI data that reveals. And when it comes to the faculties as well, so the Nature Journal survey, it has indicated that more than 98% of the professors which are at the top tier Indian universities, they belong to the upper caste or upper classes. So when it comes to the earlier framework, we had the UGC 2012 or 2012 guidelines that they relied only on the moral suasion. And ultimately, these guidelines, they were toothless. Equal opportunity cells were created, alright, although they were of no use. There were internal investigations which were marred by the institutional biasness as well. Now, at the present, we have seen that there had been shift to the enforced compliance statutory mandates, where we have seen that the Karnataka have, the cabinet have, introduced penal provision. There is also UGC's grant withholding threats, which had been included in this penal code that had been proposed by the Karnataka Assembly. In the future, we have the opportunity that there will be democratization of the elite campuses and there will be true accountability as well. But it is not the only opportunities. There may be risk as well that will be, that will come. If the opportunities are there, we will have the risk as well. And the risk will be weaponization of the laws. The risk will be of the federal gridlock and the administrative over-bureaucratization, and possibly these were the risks that were involved with the bringing of the UGC regulatory framework in 2026 that forced Supreme Court to stay the UGC guidelines. Alright, so this is also something that we have to keep in mind. Now, this is a positive step by the Karnataka Assembly that it had taken. At the same time, we have the two sides of the coin. Some things are important or they are positive, but at the same time, there are certain negatives as well which are involved. And as a student who aspire to be a civil servant, you have to weigh both pros as well as cons. Now, it will transform the moral obligation into the statutory compliance after the passage of the bill that has been passed by the cabinet of Karnataka. It guarantees that there will be representation in the grievance mechanism, like for example 80% of the quota that had been introduced in the equity committee in the Karnataka's bill. And also it institutionalizes the accountability as well through a severe financial and the penal deterrents that had been introduced in the proposed bill by Karnataka cabinet. But at the same time, there is definitional ambiguity because the concepts like indirect discrimination, they are complex to prove and they are prone to misinterpretation as well. There is the fear of misuse as well, and the critics, they fear the false polarization where we have seen that the Supreme Court have stayed the UGC rules in the same direction. And also, when it comes to the institutional autonomy, there will be heavy-handed penalties that may stifle the academic freedom, or they may cause institutions to defensively reject the marginalized candidates at all. So ultimately, these are the concerns as well that we may see moving ahead. Now, you may join me on my Telegram for the for the PDFs that I provide for the Hindu analysis every day after class. The session for the Hindu analysis that is conducted at 9:30 a.m. every day on the same channel, that is on StudyIQ IAS in English. Alright, so you may join my Telegram for the PDFs, and also you should join every day at 9:30 a.m. for the complete Hindu analysis, as well as if you are preparing for the civil services for 2027 or 2028, we have resolution batch, and the new batch, they will start from 27th of the April 2026. We have the batches which are available in English, that is in bilingual and in Hindi as well, you can enroll. And after enrolling, before making the payout, what you can use is, you can use the code BRS Live. Now this code will give you the maximum discount that will be there. Alright, so you can use this code for the maximum discount, and that will be all in this video. Thank you very much guys for joining me over here on the platform of StudyIQ. I wish you all the very best. That would be all. But before moving ahead and ending the session, do not forget to like the session, share the session with your friends, and also subscribe to our channel so that you do not miss any of the updates. Thank you. Bye-bye. Take care and Jai Hind.